my question is with regards to the decision that has, the kenyataan that has been dikeluarkan oleh the lembaga pengampunan. Of course, we've listened to two sides of the opinion. I'm just going to cherry pick on one part of the kenyataan in which it states that the sentence, the year of sentence has been reduced to 2028, and even the fine. And this is the part I'm going to state, is where if he does not pay his fine, there will be an additional 1 year of sentence being imposed. So, of course, if we look at Article 42, it entails the reprieves and what the YDPA can do to pardon someone. And even if you look at the recent Anwar Ibrahim case, such reprieves, so on and so forth, would encompass both sentencing and also conviction. But I don't think anything, after perusal of Article 42, I don't think anything states about the YDPA having powers to additionally to sentence someone. And this additional part of sentencing is what I'm referring to. Kalau denda tidak dibayar, 1 tahun extra akan dikenakan. So my question is, would that particular fact now be a loophole for it, I don't know, breaching basic structure doctrine, or even so the doctrine of ultra vires, and now that particular decision be amenable to judicial review?
That's a good question, but the answer comes from the fact that I believe it is non-reviewable, no matter how wrong or blunderous it is. Okay, I'm using a very strong term. Number two, I don't think it is wrong, because the court can say, pay this fine, in default, so much imprisonment. And the Yang di-Pertuan Agong obviously has chosen a formula of 50 million or 1 year extra, which will run successive to the already imposed imprisonment of, yes, it accumulates, not concurrent. So the short answer is, I think, first of all, he's not wrong. It is within his power. Whether another Yang di-Pertuan Agong will do that is, of course, an open question. But this Yang di-Pertuan Agong decided to do it that way.
Mr. Moderator.
I don't think this is a matter on which the courts will interfere, because the decision of the Pardons Board was, or if it's the decision of the Yang di-Pertuan Agong, if you don't pay the fine, then the imprisonment is extended by 1 more year.
No, Professor, you're wrong. It is a provision within the Criminal Procedure Code. If you go and look at the Criminal Procedure Code, sorry, my name is Manjeet Singh Dhillon. And I think that Shafee has given you a load of bullshit. Going back to the Mokhtar Hashim trial, he wasn't involved in the Mokhtar Hashim trial. He didn't have a clue what happened in the Mokhtar Hashim trial. He didn't have a clue of what transpired in the trial. He was not even there. I did the Mokhtar Hashim trial, so I'm speaking from experience. But the point is basically this, Professor, I'll tell you, there's a provision in the Criminal Procedure Code which says that in default of paying a fine, there is a term of imprisonment. So if you all go and really think about what you're talking about, what the Agong seems to have done is primarily the Agong is created above the federal court, another court. You literally have done that. I mean, when you go and change the entire fine provisions, I mean, he was fined a certain amount of money. Whether he should pay the fine or he shouldn't pay the fine doesn't bother me at all. But I can tell you one thing. There is a provision within the Criminal Procedure Code that creates what the default thing is if you don't pay the fine. Now, what right does the Agong have to change the entire structure of what the Criminal Procedure Code provides? Now, the Criminal Procedure Code is not within the right of the Agong. He sits there, whatever he does, whatever professor has talked about the provisions of pardon, etc. I'm not going to get involved in all that. I mean, I believe very strongly what has been done in this country is wrong. Najib didn't deserve to get away. He deserved to get what he got. What he will get again in the forthcoming cases is a different matter. What the Bar Council decides to do is up to the Bar Council. If, as Karen says, they feel that this is particularly right, they want to go forward, by all means go forward. Challenge it. Justiciable. It is a justiciable corporation. You just can't simply let it go like that. You want to talk about prerogatives, you talk about England. This is not England. This is Malaysia. We all have our rights here. I mean, the young lady who spoke on behalf of the Students Association, I take off my hat to her. I frankly feel that this is what the young feel. This is what the older people should be feeling. Amazing, brilliant. This is the way this country should be looking at and understanding things. But Mokhtar Hashim was not given a pardon because he got older. Ask me why Mokhtar Hashim got a pardon. And I'll explain it to you, Mr. Shafee, when you have the time. I've dealt with you, I've attended to you, I've had issues with you. But what you told just now concerning Mokhtar Hashim was a misstatement of fact and information. And you have no right to come to a forum like this and misstate information for the benefit of people here who did not know. If you go back, look at the trial, it was 1980 something, 82, I believe. Where were you in 82? Nothing else to say. Najib does not deserve the pardon, partial or otherwise. He deserves to be in prison serving the full sentence. The Bar Council has to stand up for this and make it a point. Go and challenge it if you want to. Show the world, show the country what this Bar Council does and has done. I leave it at that. But Shafee, please don't misrepresent information.
Now, I don't know why Mr. Dhillon takes that sort of an attitude. What I have just told this hall is what I have learned from the record office of the prison through a recently retired prison officer by the name of Kadir Jalani, who happens to be the only legal officer of the prison. Until today, he has not been replaced. Who cares whether I was in the trial or not? Because that's not relevant. We're talking about post-trial, whether he got pardoned or not. On record, I have been told by this officer and from the record that Mokhtar Hashim got a pardon. That's it.
I just want to comment on one thing, and that is the statement, what does the Yang di Pertuanagong have to do with the CR Criminal Procedure Code? I also appreciate your point that this is Malaysia, not Britain. But on the other hand, some of your statements are very British.
Professor, my statements...
Let me finish.
Professor...
Let me finish first.
All right, please finish.
Let me finish
Please
first.
finish.
Mr. Dhillon, if you could let Prof finish first.
Let me finish.
Of course.
Yes. Mr. Dhillon,
Yes, sir.
the Criminal Procedure Code does not override Article 42 of the Constitution.
Professor, I am not British. I studied in Britain. That doesn't make me British or white or any other color. All right? And I certainly do not come to forums to listen to presentations where everything that is being said is hearsay evidence. The man stands up and he says, I wave something. I see a seal and I'm supposed to believe him. The man says the man was sick. A prison officer tells me and I'm supposed to believe him. Look, forums are where you present information which can be factually verified. You're all, most of them here are lawyers. And we all work on information that we can verify. So hearsay, right? Double hearsay, triple hearsay from a Tansri? Wow, amazing.